Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Friday, May 1st, 2026 at 11:15 in the morning. So we're back from the floor and we're here to continue our discussions on S70, taking our testimony. Morning, Maggie. Thank you for joining us.
Good morning. Thank you so much for having me today. For the record, Maggie Lenz. I'm here on behalf of Vermont Retail Grocers Association giving testimony on S71. I'm going to be speaking to the House version 2.3 and also to the Senate version, which is probably no surprise. So thank you for the opportunity to testify. VRGA members include small retailers, grocers, large stores across Vermont. And I do want to sincerely recognize the work of this committee, the Senate, the AG's office, stakeholders. I know everyone has put a lot of work into privacy over many years now. So VRGA is in support of strong, meaningful privacy. Business owners are also consumers, and they do care about this. So we're not asking Vermont to do nothing, but we are asking for a privacy law that's strong enough to matter and clear and workable. So this is why we are asking the committee to use S71 as passed by the Senate as the framework. The Senate version gives consumers core rights. It gives consumers the ability to access, correct, delete, obtain copy of their data, along with the ability to opt out of advertising, sale, certain profiling. It requires clear privacy notices. It requires consent before processing sensitive data and data protection assessments for higher risk processing. And it gives the AG enforcement authority, provides a clear compliance path and includes strong consumer health protections, which we think are very important. And we have a lot of faith in our AG's office to enforce the provisions of this bill. So VRGA supports this version because it is strong without being unknowable. And that uncertainty is a big part of this. And I don't think it's beside the point. I think it is one of the main functions of this discussion. So our concern with 2.3, it lowers the threshold to 35,000 consumers. More concern is that it separately applies to any business that handles what the bill defines, which is broad definitions of sensitive data. That list tied together with the applicability threshold is very concerning. So the concern is not that businesses are using data, it's that these triggers will pull in a much broader range of ordinary businesses based on routine operations. So retailers and grocers are handling deliveries, online orders, loyalty programs, returns, fraud prevention, which I know the bill does call out, but there's still some uncertainty how that would work in practice. Everyday customer communications, all of which can involve data that may fall within definitions of sensitive data. So as a result of that framework, which is aimed, I believe, at higher risk data practices, it ends up applying, in our view, to standard day-to-day activity and makes it much harder for businesses to understand when and how that full set of obligations will apply. And I know you hear this time and time again, but we really do mean this consistent regional approach matters. So this ties into the applicability piece, sensitive data, that ties into our specific concerns with 2.3's definition of sensitive data. We absolutely support strong protections for genuinely sensitive information, health data, biometric data, precise geolocation data, immigration status, reproductive sexual health data, gender affirming health data, children's data, other highly sensitive categories. But 2.3 defines sensitive data so much more broadly, and then on top of that applies the strict necessity standard and bans selling questionably in our estimation, sensitive data. And that combination may be aimed at the worst forms of behavioral tracking, but retailers and grocers, they don't operate in a vacuum. So 2.3 includes provisions that do preserve, I think I mentioned this, activities like fraud prevention, product recalls, internal operations, but businesses still have to reconcile with all these other layers how those allowances with the front end restrictions on data use will work in the context of ordinary retail operations. Like I said, returns, deliveries, age-restricted sales, coupons, recall communications, measuring whether a promotion worked. They rely on delivery platforms. I think I named all those. So we like the Senate's version because it is consent-based approach to sensitive data. We think that's more workable. It does not ignore sensitive data. It requires consent. It preserves consumer choice. It allows Vermont to protect sensitive information without forcing every ordinary business relationship into a strict necessity analysis. It may be very difficult to apply. The third concern that we have is advertising. 2.3, it does permit some advertising following the conversations around first-party advertising, which I honestly found a little confusing, and targeted advertising under certain conditions. But it also places restrictions around sensitive data, which again is a very broad category under this bill, and opt-outs. And the question is not to us whether there should be limits, there should. It's whether an ordinary Vermont business can make sense of these limits, operationalize them. So, questions that I've heard, can a store use third-party email vendor to send a customer coupon? Can a store engage in, reacquisition? Can they advertise to a store a sale to people who have shopped with it before, even though it's not anything to do with the previous shopping experience? Can they measure whether a promotion worked? Can they use a platform's advertising tools without having to be experts and understand every downstream data classification? So the Senate version handles this in a clear way. It gives consumers the right to opt out of targeted advertising and sale, requires clear and conspicuous disclosure, reasonable and necessary data limits, consent for sensitive data, does not leave local businesses trying to reverse engineer the technical architecture of these advertising platforms in order to know whether a routine customer communication is allowed. The fourth concern, data minimization, 2.3, it doesn't simply require responsible data practices. It limits the collection and processing to that phrase, reasonably necessary, proportionate to provide and maintain a specific product or service requested by the consumer. And that's a major shift from the Senate version, which already includes data minimization, but requires collection to be adequate, relevant, reasonably necessary in relation to disclosed purposes, and by barring processing for incompatible purposes without consent. The concern is how the House draft functions in ordinary Vermont commerce. What is the specific product or service when a grocery store sends a coupon, uses a system to prevent fraud, processes a return, manages a delivery, handles an age-restricted sale, sends a recall notice, or tries to understand whether a promotion worked? So, and then equally, I think important to the policy itself is the process. And I think it is worth acknowledging where it has fallen short. And how to avoid these pitfalls going forward. And this is not about revisiting old disagreements, criticizing any individuals, but it is about naming a dynamic that took on a life of its own. And I do think it needs to be addressed in order to rebuild trust on all sides around this issue. Over the last several years, the process around privacy legislation, it has become unusually charged. I think we'd all agree, at least by Vermont standards. And I think legitimate concerns raised by Vermont businesses and associations have at times been dismissed as not local, not substantive, or ill-informed. And that dynamic has made it harder to pass privacy bill than it needed to be. And it has strained otherwise strong working relationships. And in most policy areas, when multiple organizations across different sectors identify similar issues in a bill, that is treated as a normal part of the legislative process. And people may disagree, they may believe those concerns are overstated, but the act of raising them is not questioned. And this debate has felt different. When business organizations have raised similar concerns to one another, it has at times been framed as a coordinated effort or a broad national campaign to mislead. National organizations pay attention to state outcomes across many issues all the time, including privacy, education, healthcare, yada, yada, yada. And while they may share the concerns of Vermont businesses, that does not make those concerns any less real for Vermont businesses. We are all arriving at the same conclusions because we're reading the same bill and encountering the same practical challenges. So what those businesses are expressing is not confusion for its own sake, but real uncertainty about how to comply and what is expected. And that uncertainty creates anxiety for people who will be responsible for getting this right on the ground. And I think in this bill, that uncertainty is not incidental or easily resolved through guidance alone. It is a central concern. A system that helps businesses get this right is what will ultimately produce meaningful consumer protection. And in closing, that's the central reason why we're asking you to support the Senate-passed version of S71 as the foundation to preserve meaningful consumer protection, consumer rights, sensitive data protections, consumer health data protections, AG enforcement, guidance, compliance support, and then come back as other states ahead of us are doing and make targeted changes to the law when you're ready. Thank you.
Questions for Meg?
Thanks, Maggie. I was reviewing the sensitive data that is in this bill. As you were talking about your concerns about what's clear and what isn't clear. And what the only part of it that seems like it could impact retail grocers is N, perhaps, the online activities of a consumer over time and across devices, websites, online applications, and mobile applications that do not share common branding or data generated by profiling reform. So, if data minimization is truly the issue and sensitive data is truly the issue, we can have conversations about whether that belongs in sensitive data or not. And so I heard testimony that said a couple of different things. And if data minimization is not even on the table, then I'm not sure that it makes sense to have this conversation. But I just, so I'm just trying to understand, is that the only sensitive data issue? Because the other pieces, if grocers are collecting consumer health data, that doesn't seem appropriate, right? The other data that's listed on here, reveals a consumer's status as a victim of a crime. I'm not sure why any grocer would be collecting that information at all. The consumer's sexual orientation, sex-like sexuality, or status. Are grocers collecting that information today?
I mean, the applicability threshold is one, right? Like processing one, it could be one person's sensitive data. And I think that it really, to us, it doesn't seem like it leaves a lot of opportunity to, I think, pull in like incidental collection that may not be the goal of the immediate process, but certainly not something that I think we'd consider sensitive data. I don't have the list in front of me. I can look through it and pull out the pieces that are concerning and send if that's helpful, but it wasn't just, I've had people raise other elements in the sensitive data. Maybe keystrokes is questionable, things like that.
So are grocers collecting that information today? I mean, that's really my question is that, this is right. This is the grocers. That's who you're.
Yeah.
Retailers
and grocers. I mean, we have large members, small members, medium members.
But are retailers and grocers sophisticated enough? Do they have my understanding, right? Specifically on grocers, is the margins are so slim that there isn't that, right? You have to do volume to make money in these industries. And so are they collecting keystrokes, right? Is that really what we're talking about here?
We're talking about all different size businesses, and I will admit I'm not intimately familiar with all the pieces of data they collect, but I do hear from members that as the sensitive data piece is written and as the targeted advertising piece is written, particularly how those two fit together, that it is concerning. Retailers and grocers of all sizes do use targeted advertising. And I think
yes. Okay, so we're not talking about sensitive data, we're talking about advertising.
I mean, all of it really, I think. But yes, I mean, because you can't, the sensitive data, there's a ban on targeted advertising to sensitive data, right? So I think targeted advertising, there are concerns, but then there's also the sensitive data piece. And just because it could include so many things under that ban, I guess.
Do grocers sell pregnancy tests?
I believe so.
Do they sell feminine products?
Mhm.
Are those a way to determine gender of an individual?
I can't answer that question. I'm not a healthcare professional, but
It would fall under
Don't know.
sensitive data. I think that's,
I send my husband shop for me all the time.
I know. I understand that, but is your husband using your loyalty card?
Yes, we share one.
Then, I mean, yes, but it also is one of those data points that could reveal that information, which would,
Not be accurate.
it might not be accurate.
So it's okay.
And could be harmful.
And could be.
and to be clear, we are absolutely not against data minimization. I think he mentioned something about us, like that being a non-starter for you. If we were saying no data minimization, you just want it to be consent-based, where there's opt-out.
So what's the question? Well, maybe not, maybe just one arrow, that's in agreement. I noticed that in the 2.3, there are, I think, 14 items that are identified as sensitive data, 6 of which look to be the same or very similar to what's in S2071. So I guess my question is, of the remaining, which are the items that you're concerned about? I think you mentioned that you thought the definition is too big. So I'm kind of, which of those, what, 5 additional? No, more. 8, I don't agree. 8 additional items in 2.3 are you concerned that it too broad? I mean, there's a bunch of them, tax returns,
Yeah.
security,
Yeah, and I don't have those identified
Okay.
specifically, but I will say, I think part of this is that some of these definitions we understand to be, or some of these components that are now going to be fit under the definition of sensitive data just haven't been tested around us. And I think part of this is just knowing that they have already been in use in other states and that it works X, Y, Z, and have that certainty.
I'm just looking at A there. Social security number, passport number, state of verification, license number. Those are pretty concrete, I would think. Anyway, if you have any additional information on the specifics of why you think this definition is too broad.
Yeah, I'm happy to do that. I also just, I just want to make sure I'm careful not to make it sound like that's these issues kind of like tie into each other, one thing feeding into another.
Yeah, I was just picking up when you said you
Yes.
thought the definition was too broad.
Yep, understood. Yeah.
Yeah, I think I can try to help us narrow down, Maggie, on because I have specific questions about sensitive data, but so the Connecticut as it's going to be triggered or whatever, July 1st, was passed in 2025. I'm gonna just compare the sensitive one, the thresholds match what we have. So they also are gonna have the sensitive data B0 be the threshold, July 1st, starting July 1st. And so the only differences between that very long list, Herb, if you're looking at your definition of sensitive data, I'm going to help you out. So the only difference
You
is.
track better than I do?
Yes, yeah. So the items that are not in Connecticut are income level or indebtedness, status as pregnant, union membership, and online activity over time across non-common branding devices, blah, blah, blah. Keystrokes, driving behavior, and cross-device online activity profiles. The so income level, indebtedness, pregnant, union membership, and online activity over time exists in other state comprehensive data privacy laws, like Oregon and things like that. The only elements that are not in any other privacy law are keystrokes, driving behavior, and cross-device online activity profiles. So out of those, would love clarification. I know you have to.
Well, I do think the
You got it
last one
later,
across, the behavior across devices, like I think that's certainly a concerning one. But it's not the only
Yeah.
one. Yeah.
Yeah, cool.
Yes. Thanks. Thanks for listening to me.
Okay, all right, okay.
Oh, good, good, good.
Is VGRA opposed to? We look at, well, and we have in here updates to Connecticut updates to their own bill. So 2025 up Connecticut updates that are in here.
Um,
Are,
Yeah.
are you supportive of those updates?
um, so I think more open to them certainly than 2.3. I think still concerned a little bit about the applicability threshold being lowered to 35K, but I do understand now that that exists in Connecticut. So I cannot say that we would support the bill exactly as it came out of Connecticut, but it's certainly a better starting place. I think we'd really have a path there.
Just what I would ask you to take back is
Mhm.
you go down that path, we're giving up a lot.
Mhm.
So we would ask the same on the other side. too.
And to be clear, my main hesitation is I can't speak. I'm not the president of the organization, so.
Take that.
Just curious, are your retailers not already having consumers that are visiting Vermont from Connecticut that they would actually have to adhere to Connecticut's thresholds? Like, are we saying that no Connecticut people, the threshold is 0? So that would mean that like a retailer would have one customer in Connecticut in order to hit their thresholds. Are we saying that Connecticut folks do
Sorry.
not come to Vermont?
I wasn't saying that, but I
Yeah,
guess I'm not understanding
So
the,
if you're saying you don't support the thresholds of
I
2025.
would say I don't support it. I just.
Sorry, I thought that's what
yeah.
you said.
No, I'm
Yeah.
not saying, I'm just saying, just like still kind of concerned. It's a new concept just in terms of Vermont, like just the lowering, right? So I can't just say, yes, we're good with that.
Yeah, so I'm just asking you to explore the fact that like if you're not okay with it and we don't put it in ours, visitors from Connecticut will have stronger rights than Vermonters that live here when it comes to sensitive data. That's what I'm saying. And I
Will it be
think we have a lot of Connecticut traffic.
visitors from Connecticut will have stronger protections? Right. And then there's some versions we're looking at where it's going to be harder for Vermont businesses to communicate with Vermonters than Connecticut. So yeah.
Yeah, I don't know what you're talking about there. We have exemptions, so yeah.
Sorry, what was the question? Or
Uh,
was there a question?
Yeah, the question was, can you explore the fact that Connecticut in July 1st will have a threshold of 0 for sensitive data for Connecticut residents visiting Vermont and buying things like pregnancy tests from Vermont retailers. But if we don't adopt Connecticut's 2025 thresholds in our Vermont law, then we're saying Vermonters are not afforded the same protections when they go to Connecticut or when they're in their home state of Vermont. So I'm just wondering how you reconcile those two things.
I don't know. I will
Okay.
think about that.
Any other questions?
Thank you so much. I appreciate the time.
Andy? Morning.
Thank you, everyone. My name is Wendy Peterson. I'm a Vermont resident and a principal software engineer at Red Hat, which is part of IBM. I work on the OpenShift team. I've been working in the software industry for about 25 years, and I'm one of the maintainers of Kubernetes, which is widely used in large companies and governments and public institutions to run cloud and data systems. I also organize locally in Vermont, so I hear regularly from people who are concerned about how their data is being used and who don't feel like they have much control over it. My professional work focuses on systems that store, process, and move data at scale. I'm a software architect. So when I talk about this, I'm describing how these systems actually behave in practice. I'm here to support keeping this bill as strong as it currently is. And I also want to share some personal context. I'm a trans woman. And right now, that's something that's being actively targeted at the federal level. So for me, data privacy is about risk. It's about whether someone can build a profile of my life, where I go, what care I seek, without my knowledge or consent. This bill defines sensitive data to include things like gender identity, health data, and precise geolocation. And to make that concrete, imagine a phone app collecting location data. If that app sees repeated visits to a specific clinic, combines that with other signals, it can infer things about a person's health or identity, even if that person never directly shared that information. That's how modern systems work. They don't rely on a single piece of data. They combine many small signals and draw conclusions. This bill also includes the concept of derived data, where systems take those signals and turn them into predictions about a person. And that's especially relevant about, with AI. And AI is what the tech industry is all about these days. Modern systems are designed to do exactly that, take large amounts of data and learn patterns from it. And you can't build responsible AI on top of irresponsible data practices. If systems are trained on large amounts of sensitive or loosely controlled data, the risks increase, both for individuals and the organizations using those systems. And that's why data minimization matters. And I want to be clear about what that looks like in practice. It means collecting the data you actually need to provide a service, not collecting everything else just in case. So we have something called a necessity analysis. And from a technical perspective, that's not a new or unusual requirement. That's something which you do when you design a system. It's just asking the simple question, do we actually need it to provide a service? It's how we do these things. So when we process a purchase, we just collect enough information to complete the transaction. For that, we don't need precise location data or unrelated behavioral data to do that. In engineering, the question, do we actually need it, is just basic. It's what makes sense. We're not introducing a new kind of burden. It's just formalizing a standard industry practice. And I also want to clarify that there are concerns about how broadly this applies, but this isn't just triggered by being a business. It's triggered by specific data practices, handling data at scale, processing sensitive data, and selling it. And these are things that, small businesses and typical retail associations aren't doing. It's something that you would do only if you want to resell it, essentially. So what's different here is that we have something that maybe could track behavior across multiple websites, combine that with location and other signals, and build those profiles to share or sell them. And that's completely different from what retailers and other folks are typically doing. And that's what the bill addresses. Another example of the kind of systems that this bill is addressing is when third-party services are used to profile customers using AI. So a retailer might use a service that analyzes customer behavior and assigns a risk sort for fraud, returns, or other purposes. This is something that's actually being marketed to businesses right now. And on its own, using the data to complete a transaction or prevent fraud can be reasonable, but it becomes higher risk when those profiles are reused or reused across context, combined with other data sources or shared beyond that original transaction. That's why we need the legislation. At that point, you're no longer processing a purchase, you're building and potentially distributing a profile about a person. And that's the kind of practice that this bill is designed to put boundaries around, especially when sensitive data or broader behavioral patterns are involved. Now, there are several different versions of this bill. From a technical perspective, I think that some concerns come from uncertainty about how these rules apply. But S71 already reflects a balance. It preserves normal business activity while addressing higher risk data practices, especially when sensitive data is involved. And I also want to highlight this approach is actually good for businesses. Each piece of sensitive data you collect becomes something you have to store, secure, and manage. So one of the most effective ways to reduce risk is simply not to collect or retain data that you don't need. From a business perspective, that also reduces cost. Less data means less infrastructure, less systems complexity, and less exposure if something goes wrong. Because when a breach happens, and they do, the cost is directly tied to how much sensitive data you're holding. So data minimization just isn't just a privacy principle. It's a practical way for businesses to reduce their costs and their risk. And this bill is aligned with that. On advertising, there is a perception that companies need detailed personal data to advertise effectively, but in practice, that's overstated. For example, placing an ad next to relevant content, like advertising hiking gear on an outdoor website, works without needing a detailed personal profile. That's just contextual advertising, and the bill allows it. What the bill limits is the use of sensitive personal data in those systems, and that's a reasonable boundary. I understand that this bill has already been negotiated and some provisions have been weakened, including removing the private right of action and relying on the Attorney General for enforcement. But even with that, the remaining protections, especially around sensitive data, are still meaningful, but only if they're not weakened further. Because for a lot of people, this isn't abstract. It's about whether their health decisions can be tracked, whether their identity can be profiled, and whether their movements can be monitored and sold. This bill takes concrete steps to limit that, including the banning and sale of sensitive data. From both a technical perspective and a personal one, I think that these protections are important. So I'd like to ask you to keep this bill as strong as it currently is. Thank you.
You, Wendy. Any questions? Tony?
I appreciate your testimony. I work in cybersecurity, so I completely understand what you're talking about, data breaches and data minimization. What I want to know is your take on one of the things we've heard a lot of is the ability to opt in with sensitive data. Why do you feel we should take that choice away from the consumer?
Why do I feel we should take the choice away to opt in? I don't think that someone should have the ability to opt in to whether or not why would someone want their health decisions to be tracked by a retailer? It just doesn't make sense.
Well, take, for example, we are, I work in real estate as well. And I might want to keep track of, say, if a person's Jewish, because we like to send out a card and it would be offensive to send them a Christmas card. And if in this situation, I would not be able to retain that data. I would just be able to, and that, in real estate, they teach you to learn as much as you can about the client and store it in your database so that you can continue to foster that relationship. And that would be an example of where perhaps with consent, someone would want that information.
Well, I mean, I think for me, I think that the risk that would be inherent in retaining that information would outweigh the small benefit that would be had by by giving that information. So I just don't think that the risks outweighs the benefits.
Understood, but what about the consumer? Don't you think they have the right to make that decision?
I think that they have the right to share that information, but I don't think that the company should have the right to hold on to it and to resell it.
Okay, but I understand that. But what I'm saying is that this bill, as it stands, it is outright illegal to collect anything other than the necessary data. And I get that.
Yeah.
And, in my databases, that's what I do. But there are situations where maybe you'll get a coupon for your birthday or something like that. Some of the stuff can be construed about sensitive data. And I can tell you one of the problems with the businesses is they are not sure. If they take something like that, they want to offer a coupon, they're afraid, well, that may be considered sensitive data. Then the Attorney General comes down on them and all that kind of stuff. What I'm saying is, why can't the consumer? I'm trying to understand why we feel that a consumer is unable to make that decision on their own.
Well, I would object to the framing of that. I don't think that I don't think that they're unable to make that decision. I just think that the regulation is in place to facilitate, good business. So like, for the same reason that you wouldn't like collect information that's, private, their personal financial information, and you wouldn't want to hold on to that. You don't have any reason to collect information that is other dangerous in other ways.
Right, what I'm saying is that a consumer should be able to decide. Now, I'll give you a lot of the crap that we see now with 80-page EULAs and consent that way. But I'm talking about a situation where consumer knows full well, they get a warning that says, look, you are giving us sensitive data. Are you okay with that? I'm trying to understand why we feel it's okay to take that right from a consumer to make that decision with their data.
Well, I guess it's a philosophical difference. I mean, here I think it's our responsibility as a state to protect people from making decisions which in the long run end up harming them.
Okay.
Yeah, thanks, Wendy. So you mentioned the private right of action. I actually feel like our committee had submitted an amendment that still had the private right of action in May, that had like a lot of hoops and barriers and things to jump through, and it had a threshold of companies making $500 million or more per year, plus holding the records of 200,000 Vermonters or more per year. There's like a lot of, plus you had to go and get like AG permission and all this stuff. So there's like a lot of hoops, and we just completely removed that and struck. And this would, on our genetic privacy bill, our kids code, our the data broker bill, but also every single Consumer Protection Act related bill that we have, going back since it was created in the 60s, allows Vermonters access the right to sue if they're harmed. And so I'm like, we haven't really talked about this with a Vermonter consumer. We've been talking about with big companies and small companies. And I'm just wondering, from your perspective, how you feel about the fact that we are saying, like, if you get hit by a car or you're driving a car and something's faulty and you crash, you can sue. Product liability and safety type of stuff. But we're at the same token, we're saying, like, if somebody takes your information and denies you a loan or denies you insurance, or or tracks you, or gives information to somebody to stalk you and then you get killed or something like that, like lots of harms that could be out there. And we're saying that, like, if you are actually harmed, which under the Consumer Protection Act, it doesn't have the things that people say they're worried about, kind of like ambulance chasing, class action. You have to prove harm under the Consumer Protection Act. And that is the reference that we are typically using. And so I'm wondering how you feel that, like, we're saying, if you are actually harmed, something really actually affects your life, it harms you in a way. And the Attorney General has testified that they do not represent individual Vermonters. They represent the state of Vermont. So a case has to be big enough and attractive enough, and they'd have to be able to recoup costs in order to go after it. So if you are harmed by a company clearly violating this law and breaking the law that harms you, you really have no option to go to court. And so I'm just curious how you feel about us taking that away from you.
Well, it's heartbreaking.
Yeah.
I mean, in some ways, it feels like kind of par for the course this year, because, I mean, so many of my rights have been taken away. I mean, the federal government is in the process of stripping away my rights, disacknowledging my personhood, essentially. Several states, they've stopped recognizing, they've taken away, like, people's driver's licenses. Transfer people's driver's licenses. Vermont's probably going to be the last bastion. At least that's one of the reasons I'm here. But I mean, again, the state exists to protect us, right? That's what it's there for. Look, we're all at risk. I know more than, I probably have more context than almost anyone in the world for understanding exactly how bad it's going to get. AI is going to take over. It is in the process of taking over everything, right? And the limiting factor is the information that it has available to us, to it. That's one of the reasons that, you know, we see such expansions in like the collection of data all over the place, is because that's the way that, you know, AIs could advance. That's why, you know, we see advancement in surveillance and levels of government and like in the systems that are marketed to businesses. I think there are responsible ways to do it and irresponsible ways to do it. And well, my company is kind of leading the efforts on the responsible ways to do it sector of things. That's what the systems I designed are all about, actually. I think that government plays an important role in like defining the framework under which all of these things need to take place. And it's not going to happen because like individuals understand, okay, well, these are the things that I need to do to make sure that the impact of these systems is limited, right? They're not going to do the things they need to do. Like right now, like people are still using communication systems, which are fundamentally insecure, like email, right? I mean, I've done everything I can, like in my personal life and my technical life, to push people's systems which are more secure. But like it's not going to happen overnight. But like, I mean, that's what we can do. Like through governance, we can kind of, you know, move the boat like a little bit more, and it takes a long time, but we all need to work together. Otherwise, it's going to be a hard thing to do.
Questions for Wendy? Counselor?
And just, I can read a little faster than I can listen. And since we plan on sending some of the portion of your testimony that you read
Sure,
to our committee assistant, that would be great.
Anything else? Wendy, thank you for coming in this morning.
Thank you very much. Thank you.
Okay, committee, it's lunchtime. So we're back here at 1. Continued discussion. We had from 1 to 2, Transcend Rural Career Connected Learning Grants. We'll hear about that. Not only on that, 2, continue on discussions on S71, the more on the healthcare realm, and also from libraries, thought, and then deeper to data. So hoping the 3-ish. No early date, no early Friday today.
Okay.